Welcome back to Contemporary Business, and I'm very pleased now to be back at the Bay Magazine. And the Bay Magazine is one of the good partners of Contemporary Business because it is the number one community-read magazine in the Western Cape, and the Western Cape is the number one tourist destination in the world. I'm so pleased to be speaking to one of the regular Bay Magazine contributors here, a legal firm called STBB, and I'm talking to Rivka Hoyi, who is a director in the firm responsible for property law and conveyancing, administration of deceased estates, and curatorships. And in fact, today we're speaking about estate administration. I know it's a very downing topic, dear listeners, but it's an absolutely crucial topic, particularly if you have a family and dependents that you need to be taking care of. Rivka, thank you so much for joining me on Contemporary Business.
My pleasure, Ivor. Lovely to be here.
You must be a very depressing partner. That's all I can say. If you specialize in the administration of estates.
The opposite. Actually, I've had to learn to really just temper my personality. I'm a very positive and optimistic and happy person, and I think maybe that helps running the estates department, and it certainly has been quite a trying year for all of us at the moment.
Rivka, I've got in front of me a document which is entitled Steps in the Estate Administration Process. And this is really a masterclass in how to administer an estate on, unfortunately, the death, and no death is ever going to be timely, but on the untimely death of an individual. Can we talk about why this is such an important process to, in fact, be almost a science in terms of how it's applied?
You know, I find that clients are always looking at the easy out, and they're looking at the most cost-effective option. And sometimes the most cost-effective option isn't the best option. Sometimes you do get what you pay for. So when people think, okay, I'm going to administer my late dad or my husband's estate, bear in mind that you're grieving. So the first thing I tell people is it really does help when there's someone who is acting at arm's length. It's really, really difficult when you are grieving to deal with. It's a process, and we'll chat about the process in a minute. There's so much documentation you need to collate. There are so many government departments that you have to deal with, and it really helps to have someone else to share that burden of the administration while you're grieving, while you're trying to just carry on with life. And certainly during this pandemic, what we found is that we're dealing with more than one relative who's passed away in the same household, maybe. So that's really, really hard to cope with that while you still have to cope with the administration process, because there are masters and legislative requirements that need to be fulfilled when one passes away, and you've got timelines within which you have to complete that process.
You know, what strikes me as I read your guideline is that it doesn't really talk about what should be done before a person passes away. And what I mean by that is, this process can take a while to release funds, or to have funds released so that a family has access to them. The real question is, and I suppose where I want to start with you, is what should be done to make provision for short-term cash flow, short-term cash requirements in a family?
Such a great question. Thanks, Ivor. I'm also going to share with you, some other documentation that you could also share digitally or online as well with your listener base. And the first thing I always tell clients is, as you just say, it's such a long process, and look at the possibility of passing away next week. Don't even think long term. Just think, okay, something happens to me this weekend. Would my family have access to cash? Would they have access to my bank account? And it's so important to ensure that you don't just have all your eggs in one basket. So, for example, we often have, one bank account or dad's bank account, and everything's just getting debit orders, everything's running off this one bank account. But who else has electronic access to that bank account, number one? And also make sure that there's a spouse who's then also got access to all her own account. And I often speak about the breadwinner passing away, because strangely enough, that's often what happens. And so it's about making sure that there's immediate cash available, and that can be for absolutely anything. I mean, you could have a last-minute funeral expense or anything at all, and your credit card's not just going to cut it. And then in the longer term, you have debit orders that are being deducted from an account. You might not even know where those debit orders are being debited, who is supposed to be paid. So I'm also going to be sharing with you, we've got a personal information checklist, and that's so important that you're able to share with your partner or your spouse or your children where all your accounts are, what your policies are, who the beneficiaries are, what your passwords and login details. That's, of course, if you trust the people that you love with, you trust your loved ones for that information. But it's so important to have available cash, certainly for, I would say for the first 3 months, you'd need access to cash, because when the estate administration process starts, things start getting frozen, like access to bank accounts. And only once the executor is appointed would you then be able to re-access those things. Even life insurance policies that only get paid out maybe in a month or two after date of death. So you need to have that little kitty to cover your basics, your groceries. You're coming up to month end. There might be all sorts of expenses. You've got rates and services that need to be paid for. And you might have any accounts that are accumulating interest. So you might want to settle a credit card, or a Woolies account, or anything at all. And just your basics. I mean, just things like transport fare. I mean, if you give one of your kids taxi fare, or you need to top up a cell phone, anything at all, you really need to have access to cash. And certainly during the estate administration process, there are also little expenses that will need to be paid for.
I'm talking to Rivka Hoyi, who is a director at STBB. And Rivka, maybe we can now talk a little bit about the stages in the process of the estate administration. It is a 4-stage process, as you put it out. It doesn't seem particularly complex, but it seems particularly cumbersome.
Yes. It will. The complications arise based on the type of estate that we're administering. So if you've got quite a simple estate, and by that I mean it's someone who's passed away who doesn't have a complicated share portfolio, and you've maybe just got 1 or 2 bank accounts, you've got a property, you've got a car, the practicalities that are involved are quite straightforward. The difficulty arises when we become private investigators and we start having to hunt things down. Make sure that someone has your income tax number, your SARS login password. These are the little things that really hold you up. Do you know where your title deed is to your property? Do you have your bond account number at hand, or someone would be able to let us know where that is? Your marriage certificate, you'd be surprised how many people don't know where their original marriage certificates are. And original documents are going to be key. So when you pass away, you're going to have to provide original IDs, original marriage certificates, original antenuptial contract, original title deed, and various other documentation. And so make sure that you know where that is, that your partner and children know where those are. And if things are in your safe, please don't be the only one that knows what your password is or where you've hidden the key to your safe. So you have to share that with your loved ones.
Can I ask you a question about that? Not the safe, but the whole issue about original documentation. Now, ordinarily there would be one original document. If one is talking about a married couple, for example, and one wants to make provision to make sure that one doesn't have to go on a wild goose chase looking for those documents should something happen, are commissioned documents not considered to be original documents?
An original commissioned document would be if that person is in South Africa. So if we're asking someone for a marriage certificate and it's and the person who passed away or the surviving spouse is outside South Africa, we'd have to have a fresh copy, certified and dated and stamped outside the country. And so it's important to know where those originals are if you're living outside South Africa. if you're in South Africa and you can only produce a certified copy, it's okay up to a point, because there are certainly going to be occasions where if I'm the executor, I need to certify that I've seen the original. So I would really, I'd hesitate to say that certified copies are sufficient, because somewhere along the line, I'm going to have to confirm to SARS or to the Master's Office that I've personally seen originals. So first prize would certainly be to have the original, but if not, then certified copies. And make sure that the certified copies are originals, because often clients can't find originals and they produce certified copies, but they're actually photocopies of certified copies or emailed scanned copies, and that's not going to be sufficient. So the actual commissioner's stamp has to be an original.
As I look through the steps in the estate administration document that you've sent us, it seems to me that the majority of this work needs to be done long before you pass away, and it needs to be done in consultation not only with your lawyer but with your accountant as well. So all of this information is in the right place, and your estate administration committee sitting around a table could literally do this work in a day, should they have done the right kind of preparation.
Definitely, Ivor. I think that it's one of the few things people do is actually think about the estate planning. And you correctly point out, speak to your attorney, speak to your accountant or your bookkeeper. We certainly work very closely with the deceased party's accountant or bookkeeper, because that person knows best what your journey has been with your finances. You might have a financial advisor as well who knows exactly why you invested where you invested. And it makes it so much easier for the administrator if all of those things are in place. And I'll often tell clients, just like your will is a letter to your family, it's your voice. So certainly leave as much documentation attached to that will, whether it's a letter of wishes. Attach a summary of all your policies, a list of who the professionals are to deal with, your private banker, your attorney, your accountant, your financial advisor, all sorts of people that have gotten you to this point where you've certainly secured your assets or your family's future. You might have quite a complicated estate where you've got trusts and you've got you're self-employed and you've got a CC or a small company. Make sure that you've got not only electronic copies saved somewhere, but old school is good. I mean, just print out those hard copies, attach all of that, and put that somewhere safely, or give it to us. I certainly store my clients' wills and all their documentation as well. So, for example, a couple passed away due to COVID. The husband passed away, and 10 days later, unfortunately, his wife succumbed to the disease as well. And so it really helped his grieving children, because they were really good and very proactive, and they were an elderly couple, and they had sent me a copy of a printout of the policy schedule that they had received from their financial planner. I had a list of exactly who to contact, and it made it so much easier to be able to contact all the banking institutions and know exactly and be able to advise his daughter. I actually knew more based on that information saved than his daughter did about what was going on in her parents' lives.
What strikes me as well is that as complicated as your estate is going to be, the person in charge of the process of winding up that estate should very definitely be not just an accountant, but most probably at the helm a legal advisor, a lawyer, or a law firm, because it seems to me that in a particularly complicated estate where there are multiple heirs, so much can go wrong in the process that's got nothing to do with how the estate is being wound up, but has to do with emotion, has to do with sibling rivalry. There must be so much that you've seen in that boardroom in this regard.
Oh my goodness, welcome to my world. Ivor, that's my day, every day. The process is straightforward. It is what it is. But each estate is so different, and it's peppered with all the personalities, and I find that it's not really just about people arguing and fighting. I think people just get anxious because the fear of the unknown. So that anxiety comes out sometimes in the worst way, and people and heirs don't particularly mean to be at each other's throats or doubt each other or suspicious of each other. But yes, there are certainly many professionals or many lay people who administer estates themselves. But I do find that there are so many avenues and so many areas of law that are touched on in an estate. And as you say, it appears so straightforward at the outset, and then all of a sudden a complication arises, or someone has a very straightforward estate. But if I look at their title deed, there's maybe a condition. Someone passes away and he had left a right of usufruct for his elderly dad to live in the property. Now what? If you're not an attorney, and especially maybe a property attorney, to know what to do about those title deed conditions, or there's creditors that come out of the woodwork, or even debtors that we need to deal with, or now your dad's passed away and he owned a flat and he's got a tenant in there. What do we do about the tenant? And the tenant's not paying arrears, and so on and so forth. And so when you come to an attorney, certainly we can deal with all of those issues. If you are attending to an estate on your own, you need to contact us to assist with that. If you go to an accountant who's attending to the estate administration, the accountants can certainly ably do so, but at some point when there's a property involved, they would need to speak to us as conveyancers, because property transfers can only be attended to by conveyancers who are property attorneys.
How expensive is the process of winding up an estate? Obviously at the back of every person's mind is, how can I save that tax burden eroding into the value of my estate by taking shortcuts? Is this really an expensive process to go through if one does go to a professional estate administrator such as yourselves?
The estate administration process involves various steps, and so various costs are naturally incurred. For example, whether you do it on your own or you go to an accountant or an attorney, there are certain expenses that would have to be paid anyway.
And those are regulated
example,
expenses. Those are regulated.
So regulated, yes. So regulated expenses, according to tariff, that would be master's fees, and of course tax. Taxes are regulated, and you can't get away from the various taxes involved. The executive's fee of 3.5% is negotiable, but again, as I said, you get what you pay for.
And it's a tariff-based fee, so it's not your legal firm. It's a 3.5%, which is regulated by law.
Definitely, and so to the transfer costs. So when we have to transfer property out of an estate to a surviving spouse or to heirs, then certainly we have to follow the tariff fees on that as well. And one of the tips that I often give clients is, really look at your estate. Sit down this evening and have a look at your estate. Just run through your assets in your mind and think, I've got these assets. Do I also have the cash to administer this, for someone to administer the estate, to pay the various costs involved, to transfer the assets to the heirs? Do I have sufficient cash liquidity in my estate to cover my taxes? And bearing in mind that your debts don't die when you pass away. SARS comes to collect, certainly so do every other creditor. So certainly make provision for enough cash liquidity in your estate, and also, very importantly, look at your life insurance cover and see, do I have sufficient life insurance cover to cover all of these, and who is that life insurance being paid to? If it's being paid to my surviving spouse, does she know that she's going to use that money to cover the debts? And it's a question that I pose to clients, because when the surviving spouse or the beneficiary of that life policy gets paid out, in that person's mind, they might think, well, that's for me to live on. So now I come a knocking and ask for costs to be paid. So make sure that your loved ones are aware of what you've put in place and why you've left certain monies to that specific person to cover expenses. And there's so many policies and things out there at the moment where you can really just top up a little bit so that you've got sufficient cash liquidity to cover all of those expenses. But they are regulated and legislated, and so you can't get away from them.
Rivka Hoye, STBB, this has been an absolute masterclass in something everybody should be considering. It's been an absolute privilege having you on Contemporary Business. Thank you so much for joining me.
Thank you so much. I've enjoyed the chat. Keep well and stay safe, everyone. Bye.
Bye-bye.